Void marriages under Hindu law. The term void means null. Hindu marriage's context is religious and is considered as a part of the life of the soul. For a valid Hindu marriage, certain essential conditions prescribed under Section 5 of Hindu Marriage Act 1955 has to be fulfilled by the parties, otherwise the contravention of the condition can lead to void or voidable marriages. Section 11 of Hindu Marriage Act 1955 is dealing with the void marriages. This section says any marriage solemnized after the commencement of this act shall be null and void and may, on a petitions presented by either party thereto against the other party, be so declared by a decree of nullity if it contravenes any one of the conditions specified in clause first, 4 and 5 of section 5. A Hindu marriage will be considered as void ab initio, void from the very beginning on the three grounds as laid down under section 11 of Hindu Marriage Act 1950. Bigamy. The term bigamy means the act of entering into a marriage with one person while still legally married to another. When the condition of a valid Hindu marriage is as per section 5 clause 1st of Hindu Marriage Act 1955 says that at the time of the marriage, parties to the marriage should not have a spouse living. If this condition is violated, then it will attract the section 11 and section 17 of Hindu Marriage Act 1955. Section 11 of the Act would make the marriage void, while the Section 17 of the Hindu Marriage Act 1955 would make the marriage void and further make the offending party under Section 494 and under Section 495 of Indian Penal Code 1860 liable for some cases. Smriti Yamunabai versus Amand Rao. In this particular case, the Supreme Court observed that second wife is not a wife because second marriage is void ab initio, and in void marriage, wife cannot claim maintenance, which is provided under Section 125 of CRPC, Code of Criminal Procedure 1970. Second case is Bhagodi, Kanna Babu and other versus Vagina Pedamma and others. In the case, the court held that second marriage is void ab initio and the property cannot be inherited by the wife of second marriage, and this ruling was also followed in the case of Swaminathan versus Palanimamal others. 2. Degrees of prohibition relationship. The term degree of prohibited relationship is defined under Section 3 Clause G of the Hindu Marriage Act 1955, and for a valid Hindu marriage, Section 5 Clause 4 is prohibiting marriage between persons who are within the degrees of prohibited relationship with each other, and violation of this condition will attract Section 11 and Section 18 subclause B of Hindu Marriage Act 1955. Section 11 of Hindu Marriage Act 1955 makes the marriage void within the degree of prohibited relationship, and the contravention of Section 5 subclause 4 of the Act makes it punishable under Section 18 subclause B of the Hindu Marriage Act 1955 with simple imprisonment which may extend to 1 month, or with fine which may extend to 1,000 rupees, or both. But Section 5 subclause 4 of the Hindu Marriage Act 1955 also says that if the custom or uses governing each of the parties to the marriages is allowing the marriage within the degree of prohibited relationship, then marriage will be considered as valid marriage. Smriti Sakuntala Devi versus Amarnath cases. In this case, it was observed by the court that if there is custom existing which is allowing marriage between the parties within the degree of prohibited relationship, then the custom must fulfill the requirements of a valid custom, and the existing custom must be reasonable if it should not be against the public policy. Third up, Sapinda relationship, second section 5, subclause 5 of the Hindu Marriage Act 1955 lays down essential condition that for a valid Hindu marriage, the parties are not sapindas of each other. If the parties are sapindas of each other, then it will attract section 11 of Hindu Marriage Act 1955, which makes the marriage void, and the contravention of condition laid down under section 5 subclause 5 will attract section 18 subclause B of Hindu Marriage Act 1955, which makes the parties punishable with simple imprisonment, which may extend to 1 month, yeah, with fine, which may extended to 1000 rupees, yeah, both. But section 5 subclause 5 of the Hindu Marriage Act 1955 also says that if the custom or uses governing each of the parties to the marriage is allowing the marriage between the sapinda relationship, then that marriage will be valid and binding. Conclusion: void marriage is void since it's in sections, and when the marriage is regarded as void, it is considered that it has never having taken place, and if the condition is specified in clause 1st, 4 and 5 of section 5 of the Hindu Marriage Act 1955 is contravened, then it